In 1859, an abolitionist named John Ritchie purchased 160 acres of land in Topeka, Kansas. Following the Civil War, many former slaves settled in the area, building homes on land that Ritchie gave to them. After John Ritchie passed away, the Topeka School District bought the land and established a school for the African American children living there. The school was called Monroe School, and by 1927, it had become one of 4 segregated schools reserved for African American children.
Segregation is a post-Civil War reaction against Reconstruction. So what happened in 1896 is that the Supreme Court gave an official stamp of approval to segregation under the principle of Plessy versus Ferguson, which is based on the idea, at least, that the Equal Protection Clause of the 14th Amendment is satisfied so long as the separate facilities are equal in some way.
So the NAACP decided that it wanted to attack these facilities that were made available to African Americans, but that were still separate, by saying that the facilities weren't equal. So that began the process, and we get a number of decisions in which the Supreme Court struck down separate facilities as being unequal. Because the core of all this argument was whether or not the separate facilities were equal.
By the early 1950s, several victories had been achieved in ending racial segregation in education. Cases such as Mendez versus Westminster had brought an end to the segregation of Mexican American students in California, and U.S. Supreme Court cases such as Sweat versus Painter, McLaurin versus Oklahoma State Regents, and Sipuel versus University of Oklahoma had helped end racial segregation in graduate and professional schools. However, in primary and secondary public schools, the doctrine of separate but equal was still the law in many states, and African American students remained segregated on the basis of race.
In most of the Deep South, in most of the former states of the Confederacy, those 11 states, of course, there was just absolute segregation at all levels of education. 17 states, however, including those in the Deep South, had some laws that prohibited integration or prohibited black students and white students going to school together. In the state of Kansas, the elementary schools were segregated, but the junior or middle and high schools were not. The argument was made that the elementary schools could be segregated because they would provide special transportation, for example, for black students to attend the black elementary school when they couldn't attend the white elementary school.
Linda Brown was an African-American third grader from Topeka, Kansas. Although there was an elementary school just a few blocks from her home, it was reserved for white students only. In order for Linda to attend school, she needed to walk 1 mile through a railroad yard in order to catch a bus that would then take her to the Monroe School. Frustrated that their daughter was unable to attend the school closest to her simply because of her race, Linda Brown's parents joined with the parents of some other African-American children and brought suit against the Topeka Board of Education in a U.S. District Court.
Now, of course, the state of Kansas argued Plessy versus Ferguson. Both blacks and whites are segregated from each other. There's no racial discrimination. They both have, the law affects both of them equally. And if we're providing equal education and equal facilities, then we're not violating equal protection of the law. And therefore, our system is constitutional.
And the brilliance of the NAACP was to say, let's cut through all of that and just show, you look at these intangible factors, and when you stigmatize kids and when you separate them on the basis of their race, you are telling them they are less than, they are inferior, and they are not going to learn in the same way. Therefore, they are not getting the same education that they're entitled to under the 14th Amendment.
In other words, the NAACP their end game was not to have the black schools be exactly the same as the white schools. Their end game was integration. And the reason that they said it was necessary was because there was evidence from psychologists and other expert witnesses that basically said, when you segregate black children and white children in this manner, And because those school facilities are usually nowhere near equal to each other, it is essentially inflicting psychological harm on Black children. And this kind of harm is one that is not constitutionally permissible under the 14th Amendment's Equal Protection Clause.
A three-judge U.S. District Court agreed that racially segregated public schools had a detrimental effect on African American children. Nevertheless, the court declined to order the desegregation of the public schools.
So the NAACP had a perfect district court opinion. The district court opinion made a finding of fact. This caused harm to the students. It said then as a finding of law that we have to follow Plessy versus Ferguson, or otherwise we would stop this segregation. The plaintiffs knew that they could go to the Supreme Court and say, separate but equal is not a doctrine that should continue because it leads to a court who wants to change the system not being able to change the system, even though the court found it was harming the children. So this was a great case to go forward. It was what they'd been waiting for.
At the same time that case against the Topeka Board of Education was being heard, other cases were being filed in the states of Virginia, South Carolina, and Delaware. In these states, African American children were required by state law to attend racially segregated public schools. These three cases, along with the Topeka, Kansas case, were consolidated and appealed to the U.S. Supreme Court, where they were to be argued together. The case was known as Brown versus Board of Education of Topeka, Kansas, and it would attempt once and for all to strike a fatal blow to the doctrine of separate but equal in public education.
Brown actually took a really long time to be decided. It came to the Supreme Court in 1952, where Chief Justice Fred Vinson presided over the case. And in the original breakdown of votes, it was 4 justices wanted to strike down separate but equal, 3 were ambivalent, and 2 actually wanted to uphold it. And so they decided, well, there's too much dissension, let's just hear the case again. And they wanted to hear the case again, and this time they instructed the lawyers to present more about the 14th Amendment. Well, Supreme Court justices know about the 14th Amendment. They didn't need to hear about the 14th Amendment. They just wanted to see if they could get a little bit more consensus on the court. And then unexpectedly in 1953, Chief Justice Fred Vinson died.
And now President Eisenhower had it within his power to appoint a new Chief Justice to the Supreme Court. And he picked Earl Warren, who was governor of the state of California, Republican, like President Eisenhower. When he gets over to the Supreme Court, he knows that you have to have a unanimous decision, not a divided decision, because it's going to be controversial. You want the whole voice of the court. He wants a 9-0 decision.
The members of the Supreme Court were vastly and very aware of what they were doing and the type of political pushback they would get. Felix Frankfurter, as well as Chief Justice Warren, was determined to get the other members to go along with striking down segregation, to overturn Plessy. And so the members of the Supreme Court, they were arguing back and forth about why they should just leave this case alone and not rule in favor of overturning Plessy, or, indeed make a strong statement finally to bring the South, as well as the country, into the 20th century.
A decision in Brown would say to the South in particular, and into some other states that had a different kind of segregation, that you can't do this anymore. You have to make the children go to school together. You have to go against your social custom and do this because we think the Constitution requires it. So it was really important for this to be unanimous, because if there was a break in the link of the chain, then people would try to march through that to soften the ruling, to make it go, not really apply. So it was important that if they were going to overturn separate but equal, that it be unanimous.
And so Warren personally lobbied every single justice who was thinking of dissenting. And he finally got it down to 8 versus 1. And Stanley Reed, who was a Kentuckian, was the lone holdout. And Warren pulled him aside and he said, "Stan, you're all alone now. You got to decide what's best for the country."
Finally, in May of 1954, the United States Supreme Court announced that it had reached a decision, and it was unanimous. Instead of weighing and comparing the equality of racially segregated schools on such things as buildings, curriculum, qualifications, and salaries of teachers, Chief Justice Earl Warren said the court had directed its attention to the heart of the matter, the effect of racial segregation on children.
What the NAACP did was brilliant. They brought in a series of psychologists who had tested young black students throughout the South about their self-image and what this negative self-image did to their ability to learn. One example is they'd gone throughout the South and asked, would have dolls in front of students, a doll that had dark skin, a doll that had light skin. And they would ask which doll they wanted. And invariably the white students would pick the white doll, almost 100%. And almost 100% of the black students would pick the white doll. So the result of all this was a conclusion that it doesn't matter if they have the same textbooks, it doesn't matter if they have the same classrooms, it doesn't matter if they have the same student-teacher ratio. The effect of segregation is to harm these children, and it is unconstitutional because it violates equal protection when you harm students because of their skin color.
Speaking for the unanimous court, the Chief Justice stated,
"To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone."
All 9 justices agreed that racial segregation in public schools was not only unconstitutional, but was also harmful to African American children. The impact, the court said, was even greater when the segregation was sanctioned by state law. Chief Justice Warren stated,
"We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of the equal protection of the laws guaranteed by the 14th Amendment."
Although the court's ruling in Brown v. Board of Education marked a turning point in the nation's history by ruling racial segregation in public schools unconstitutional, the decision was met with resistance in many states. It soon became clear that racial school segregation would not end simply because the U.S. Supreme Court had declared that it should.
The Supreme Court issues decisions. How was the Supreme Court going to enforce this rule? It doesn't have an army. It has only its ruling. So the question then became, for those who were very much opposed to integration in schools, does this case apply to our state, to our school system? We weren't involved in that case. We didn't argue that case. Cases usually only apply to the parties. The court's order doesn't apply to us. We weren't involved in that case, so we don't have to follow it.
The states and the governors of states who refused to integrate generally relied on this idea of state sovereignty. In other words, states' rights. What they were saying is the United States Supreme Court does not have authority over us because on this issue of education, it's our decisions that rule, not the United States Supreme Court.
You had a whole cadre of folks in the South, Southerners, who decided we're going to resist. They called this the massive resistance movement, in particular in Mississippi, Alabama, Georgia, South Carolina, Louisiana, where they developed what was called the massive resistance. 35 Southern congressmen, for example, published what was called the Southern Manifesto, basically saying that we are never going to desegregate. We don't care what the Supreme Court says. They developed all kinds of ways of resisting desegregation. They shut down school systems in Arkansas and in Virginia, where the state legislature just literally decides we're not funding public schools, particularly if they're going to be desegregated.
In 1955, the Supreme Court heard re-argument in Brown v. Board of Education, too. The court was again unanimous, and Chief Justice Warren once more spoke for the court.
The cases are remanded to the district courts to take such proceedings and enter such orders and decrees consistent with this opinion as are necessary and proper to admit the parties to these cases to public schools on a racially non-discriminatory basis with all deliberate speed.
So the Supreme Court thought that that would mean that there'd be time to get people to go along with it without violence. And they sent it back down to the district court levels for each school district to help to deal with the school district and maybe together to come up with a plan. But instead of resulting in cooperation and moving forward, it gave time for violence and resistance.
And this went on all through the South with school districts not obeying, lawsuits being brought, federal district judges saying the law is you have to desegregate. Those judges often being threatened and fear of their lives for ordering desegregation. In Little Rock, there was rioting when the local federal court there ordered the desegregation of the Little Rock schools. It was so bad that President Eisenhower had to send in federal troops to take the children to school to prevent them from being harmed.
We look at Brown versus Board and we think that this is a really heroic decision where changes happened overnight, but 10 years after Brown was handed down, only 1.2% of blacks attended an integrated school in the South. And it took a really long time for anything to actually happen on the ground after Brown versus Board. It took the actions of other political actors to help implement it, actually. So the court can only make decisions. It can't enforce them. It has to rely on, for example, the executive branch to execute the decisions. And so it was a big deal when Eisenhower stepped into Arkansas and signaled that he was going to enforce Brown versus Board.
In 1992, Linda Brown's elementary school, Monroe School, was declared a National Historical Landmark, and today it remains a symbol of the struggle for civil rights. And in May of 2004, the Brown versus Board of Education National Historic Site was opened in Topeka, Kansas, on the 50th anniversary of the historic ruling.
Broadly speaking, in sort of the overarching picture of, let's say, desegregation and integration in our country, Brown is probably the most important case in modern American history because it strikes down Plessy. It sort of completes the legal phase of the civil rights movement. I can't emphasize enough how important it is because it becomes a catalyst for everything that sort of followed afterwards. Dr. King and the Montgomery bus boycott had a sort of a legal basis, and the legal foundation to start their fight against segregated seating on the buses in Montgomery.
The effect of Brown versus the Board, there's no way you can undersell this. This was a point in our national history that changed us as a nation. We now have an African American president. We have desegregated schools. Interracial couples walk down the street and nobody even notices very much. We are an amazing country in terms of actually being integrated in a meaningful way, in that we accept the fact that we have racial diversity in our country. And that has opened us up as a country, not just on the black-white issue, but with regard to Asians, with regard to Latinos. I mean, it is a different country than it was in 1954, and Brown was an essential part, probably the most essential part of that. It's been a long, hard path, but we've come such a long way in this short amount of time. And the first big step was Brown versus the Board. I personally hold it as, when I teach it, when I read it, to me it's almost sacred that it did this much good for this country.